Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
And welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is the Game Over? New Challenges to the Antitrust Exemption for Major League Baseball. While baseball's designation as America's national pastime might be debatable these days, it's nevertheless a big business consisting of Major League Baseball with 30 teams divided equally between the National and American leagues and over 250 minor league teams of various levels. In 2019, the last full season before the COVID pandemic, Major League Baseball's revenue exceeded $10 billion. A little over 100 years ago, the United States Supreme Court ruled that Major League Baseball was not subject to the antitrust prohibitions of the Sherman Act. The decision was called Federal Baseball Club versus National League, and in it, Justice Oliver Wendell Holmes, writing for the court, concluded that exhibitions of baseball are purely state affairs that do not constitute interstate commerce, and moreover, that personal effort not related to production is not a subject of commerce. Ever since then, baseball's antitrust exemption has been upheld twice by the Supreme Court, leaving baseball in the unique position of enjoying antitrust immunity that no other sports league enjoys. Lately, however, efforts are underway in Congress and the courts to eliminate this oddball exemption. We'll hear more about that in the next half hour. My co-host today is Melissa Maxman. Hi, Melissa.
Hi, Alicia.
Hey, Melissa, would you like to introduce our guests?
I'd be delighted. I am particularly honored and happy today to be introducing two of my dear friends and also two of my comrades on the Exemptions and Immunities Committee of the ABA Antitrust section. Both Julian and Sathya are vice chairs of that committee with me. Julian Perlman is a partner in BakerHostetler and focuses on antitrust and other complex commercial litigation. Julian has been involved in cases on behalf of the various sports leagues and teams and was part of the trial team that successfully defended the ATP Tour from antitrust claims in a jury in federal court in Delaware. Sathya Gosselin is a partner at Hausfeld in Washington, D.C., where he is active in the firm's antitrust, competition, and intellectual property and sports and entertainment practice areas. His practice includes a special emphasis on representing athletes and sports businesses, and he's a frequent speaker on sports law issues. Welcome to both of you.
Thanks so much, Melissa.
Thanks. It's a pleasure to be here.
So I'm going to start off with a softball, bad pun, that I'd like you both to answer in whatever order you prefer. My question is, the federal baseball case, do you think it was correctly decided?
I'd like to pounce here if I can. This is Sathya. I don't think we can have a serious debate at this point in time about whether federal baseball was correctly decided. I think we can have a nuanced conversation about what its continued vitality might be as a matter of law. But even 50 years ago, the Supreme Court in the Curt Flood case made clear that professional baseball is a business and it is engaged in interstate commerce.
I think another way to look at it is not to question whether it was correctly decided in hindsight, which is, of course, 2020, but to ask why and if we can understand how it was decided in 1922, where I do think, we have to put on our hats and remember what 1922 might have been like. Their primary revenue from baseball at that point, if you're viewing it as a business, was the sale of tickets. And those tickets were sold to people generally within one state. And the belief was that with the stadium located in one state, it therefore didn't, at least in part, impact on interstate commerce. I think you also have to think about, what does that really mean to say that baseball was not subject to interstate commerce? I mean, really, that's saying that it's not a matter for the federal government, for the Congress to be regulating it. And I think that you have to view it in that way, particularly as this case was only 60 years after the Civil War. I mean, that's as recent as Vietnam was to us in our collective consciousness today in America. So I think you kind of, to assess whether it was correctly decided, have to remember when it was decided and the unique features of that time.
I have always been under the impression that the 1922 case was, they didn't actually decide that baseball should be exempt so much as it was dicta, and then it's sort of rolled over and has been quoted and adopted since, and it's become stare decisis. It's become part of antitrust law. Do either of you disagree with that?
Well, I do think that it was a holding of federal baseball, right? That at that point in time and on that record, right, recognizing Julian's point, the business of exhibiting baseball games professionally was not a matter of interstate commerce and was a purely state-by-state affair. Julian, I don't know if you feel differently about that.
No, again, I think that the ultimate question here, and it's coming up in various contexts, is what is the value of stare decisis? I mean, to what extent are we going to protect the exemption because that's the way it was done historically? But I think that the reality and the reason, as Sathya said, that the Supreme Court has now acknowledged that certainly the finding that baseball is not involved in interstate commerce is accurate, because since then it has become more involved in interstate commerce. I mean, just to bring it back to 1922, this was a time where there was no real radio, there was no television exhibition. The real sort of interstate exchange of baseball information was probably the telegraph and teams traveling from one location to another, where then, again, the baseball stadium was in a single state. So again, in that context, I think you can at least understand how the court came out as it did. Again, keeping in mind the sensitivity and importance of baseball at that time, which I think was probably unique. It truly was the national pastime. It was a great example of the American melting pot. I mean, if you went to a baseball stadium in the 1920s, it was shockingly diverse, all different people from different economic backgrounds coming together. And I think you see the sensitivity of the court to saying, we are going to let Congress now legislate this national pastime, as opposed to leaving it as a matter to the states. Therefore, if it's not subject to interstate commerce, presumably the states can regulate it.
Well, and I think those are all very good points, and it's important to keep in mind. But I think we also all recognize that just as products and industries change over a century, this Supreme Court has changed over the last century and has showed a real willingness to overturn prior precedent. Meow. But anyway, moving right along. What would each of you say the effects of the exemption are on baseball professionals themselves, the people who are playing, and also on consumers, the people who are buying, paying to watch the games? And I realize that it's not merely ticket revenue anymore; it's television and everything else. So I don't know who wants to start with that one.
I can start with that one. I would draw a distinction between its effects on professional Major League Baseball players and minor league players and consumers. Professional baseball players, in the wake of the Curt Flood Act of 1998, now can subject Major League Baseball, its teams, right, to antitrust scrutiny insofar as the underlying conduct relates to the employment of professional baseball players, right? So the reserve clause issues that animated cases like Curt Flood's and Toulson before that are no more. When it comes to minor league players, they enjoy no such antitrust scrutiny, and there's been a host of antitrust challenges surrounding conduct and treatment of minor league players and teams. And on the consumer side, I think consumers are forced to live in a world with reduced competition, right? When it comes to agreements among competitors that are not subject to antitrust scrutiny when it comes to team locations, or things like ticket sale prices, or the number of teams, things of that sort.
And I would say that there have been benefits largely. I mean, from the consumer perspective, let's situate baseball against other sports. For a sport that has enjoyed an antitrust exemption, they have more output than other sports at a lower consumer price. There are more professional baseball games to watch, and tickets are generally about half as expensive as the other professional sports. From a consumer's perspective, I can't deny that if we're assessing this from an antitrust perspective, it's been positive. I don't know that it's directly related to that, but as you look at its effects and as they've been manifested, the consumers have a positive experience. They also have a stability of the major league teams that they would not have in other sports, quite possibly. While other sports have approval rights over movement of cities of teams, in the case of Major League Baseball, there tends not to be as much movement. And some think it might have something to do with this exemption, though there might be other reasons. And I think that benefits consumers. The continuity of the teams that they grow up supporting and the legacy. And I think that Sathya is absolutely right. When you're talking about the implications of the exemption for baseball, it's largely a question of the impact on the minor leagues because of things that have happened since the original federal baseball decision. And I think that even the minor leagues benefit consumers of baseball. And you do not see the same investment in a minor league that you do in baseball and other sports. And without the exemption, it remained protected in the Curt-Flood Act. I don't think you would see the same organized structure and investment in minor leagues, which also benefits consumers. I think as to the players, and certainly there are other stakeholders, but obviously the players come to mind quickly as one of the major ones. In terms of Major League Baseball players, they're not situated any differently than in other sports leagues. Again, it's really a question of the minor league players. But again, they're being given an opportunity to play in a minor league that is supported unlike in any other sport. So I think including from players, particularly players who dream of playing in the major league and want to make that next leap, the exemption has had positive effects.
That segues right into what I was going to ask you, and I was going to follow up with you, Julian. Let's talk about the minor league's role in bringing around its current situation. Can you describe for our audience a little bit about the current litigation over the exemption and what they're claiming and what the perceived problems are that they're complaining about?
Sure. Again, and I will ultimately kick this to Sathya, who I've heard speak about this topic and has some real insights, and I don't want to take any credit for them. But there is an irony to the fact that there are certain minor league teams now litigating against Major League Baseball, essentially complaining of the exemption, where at times they've also supported it. To talk about the current pending litigation, essentially what happened was Major League Baseball decided to reduce the number of affiliated minor league teams with each baseball club. And some of the minor league teams have objected to this and brought an antitrust claim in the Southern District of New York that was ultimately dismissed on the basis of the exemption that we're all talking about today, which was a surprise to no one. But it was ultimately a challenge to the ability of Major League Baseball to structure the minor league, and in the view of these complaining teams, reducing the amount of output from the minor league teams. It's a basic idea. We want to not have restraints that reduce output. And while it might appear to be that, I think the reality is that it is a necessary restructuring to make the Major League Baseball commitment to the minor leagues efficient and effective, to better spend the $1 billion that Major League Baseball spends every year supporting the minor leagues. At the top, Alicia noted that their revenues are $10 billion a year. $1 billion of that goes to supporting these teams, a minor league system to give these players a chance to develop. And ultimately, the number of those teams was cut down, and the ones who did not make the cut have objected to that. I think that my personal view is that they have a little bit of an obstacle. I think that from a consumer perspective, there really isn't that much harm here, and there may well be benefit to a better story coming out of the leagues, better players, better, focusing that $1 billion on fewer teams instead of more. And I think that the way that they've defined the market is interesting, as sort of a competition between minor league teams for association with Major League Baseball clubs, which doesn't necessarily, call out a focus on consumers.
Sathya, what do you think about that? How would you respond?
Well, I've been hearing in my good friend Julian's comments, right, a number of assertions about the pro-competitive effects of Major League Baseball and its individual teams' conduct. And, one thought that comes to mind is that antitrust exemptions, as we all know, are rare and narrowly construed. Here we have one that there's a near consensus on being incorrectly decided. And it strikes me as appropriate to evaluate these types of arguments, right, about the pro-competitive justifications of Major League Baseball's conduct, right, whatever their answers might be, rather than have the entire debate shielded by this outmoded Supreme Court case and its limited antitrust exemption.
I think that's a valid point. I think we also have to be careful, and we haven't talked about this just yet, but in the event that the exemption is repealed, how do you approach that? I think that the concerns expressed by the Supreme Court in Toulson, and I think the Flood case, regarding the impact of a judicial decision that eliminates the exemption, unleashing a floodgate of litigation, and that perhaps Congress is the better body to address this issue. And if there is going to be a change to the exemption, that it should be Congress that does that. Given that opportunity now for over 100 years, Congress has decidedly not eliminated the exemption. Again, the Curt Flood Act largely preserved it. And at least as it actually impacts Major League Baseball, namely carving out the minor leagues.
Well, I don't know if you want to respond again, Sathya, but it's sort of, this segued directly into what I was going to raise as my next point, and I want to direct this to Julian. Let's talk about the practical significance of these exemptions, particularly given the Sports Broadcast Act and the standard labor exemptions. How does that factor in? And I know, Julian, why don't you explain to our listeners what I'm talking about?
Sure. I mean, what you need to keep in mind is that as a 100-year-old case, as federal baseball is, there have been other intervening developments that obviously impact antitrust law and these specific issues that have made that decision perhaps have less of an impact than it would have absent those subsequent developments. Those include exemptions that, for example, protect unions. If you think about it, a union could arguably be a combination or a conspiracy and restraint of trade. And we've seen also concerns that agreements between unions and employers might be anti-competitive for the same reason. We've had developments in the antitrust law to address that, namely the statutory labor exemption and non-statutory labor exemption in cases that have developed that. Similarly, the Sports Broadcasting Act changed or eliminated the ability to object to sort of the mass pooling of media rights. And so one of the exemptions that baseball would have enjoyed with an antitrust exemption would have been presumably to antitrust concerns about the pooling of broadcast rights. But now this is a much more settled area of the law, though I suspect Sathya might disagree with that. But I think that what you've seen is, again, because of these developments, because of the Curt Flood Act, then subsequently specifically saying that Major League Baseball players have the rights of players in any other sport to sue for antitrust violations, that, again, you really see the exemption playing out in the minor leagues. And to make an additional point, playing out in terms of the congressional threat that is constantly hanging over the sport. I think that has had benefits. The fact that baseball has enjoyed this exemption and Congress has historically at times threatened to take it away has led baseball to do things that, again, are pro-competitive and that have benefited people. So essentially the exemption's both a carrot and a stick.
So let's talk about the legislative front. What's going on? Sathya, do you want to address that?
I can probably touch some of this. I mean, I'm glad that we're getting to this because there's really been a groundswell over the last few years of renewed attention to baseball's antitrust exemption, and it's come in many different forms. Most recently, at least to my knowledge, the Senate Judiciary Committee sent Major League Baseball a letter asking them to detail all the reasons why they still need this antitrust exemption. I understand that there was a plentiful exchange there. Bernie Sanders and even Ted Cruz have been quite vocal about the possibility of ending this antitrust exemption, and Bernie Sanders even had a bill in the Senate proposing as much. And against that backdrop of renewed attention, we have the Alston decision, admittedly about college athletics, right, from the Supreme Court in 2021, which has a discussion by Justice Gorsuch of the baseball exemption that is notably in the past tense and strikes me as a little doubtful about the continued vitality of the baseball exemption. That's just a small sampling of what's going on today. To my mind, I suspect that Julian would have more to add on both the legislative and the litigation fronts.
Julian?
Yeah, I mean, again, the Supreme Court has repeatedly stated that if this exemption is going to be modified, Congress is the body to do it. And you've seen in the Republicans and Democrats have both raised issues about the exemption. And Bernie Sanders has been particularly critical in the most recent Congress about it. I think that any solutions that come out of Congress might be a little bit more in doubt right now, and it might be a little bit hard to corral people to move forward on this issue. But that is where it should happen, particularly to protect against the sort of retroactive change of law, which again would unleash a flood of litigation on an issue which a lot of stakeholders have at least assumed has been decided.
Sathya, do you have anything to add on that point?
No, I'm looking forward to seeing how this plays out in litigation circles and in legislative circles in the coming year. I suspect that we'll still be talking about this by the end of 2023. There's a lot to come.
Well, just to sum everything up then, Julian, what are the strongest arguments in favor of preserving the exemption, both legislative and judicially?
I mean, I hate to think of this as one of the stronger arguments, but perhaps it is that the implications are not as vast and broad as many people would assume. What we've heard today is that baseball is in line with most professional sports in terms of how it's treated under the antitrust laws. What is different, perhaps, is particularly the minor league, the structure of the minor league, its rigidity. And I think the investment in the minor league. The complaint, to acknowledge it, is that typical minor league players, they make about $12,000 a year. Again, $12,000 a year being able to pursue an opportunity in a junior level that no other professional sports supports, but with $1 billion of other investment surrounding the program. When you actually look at that, the amount of money spent per player is well over $100,000 per year, which in some ways should be considered compensation particularly when we're evaluating its fairness.
Well, I don't think the minor league players would want to be taxed on it. Sat, what are the strongest arguments for doing away with the exemption?
I've echoed some of them already today. Federal baseball was wrongly decided then, and it's wrong today. Modern day professional baseball is a multi-billion-dollar enterprise that undoubtedly operates in interstate commerce. Every other professional league in the United States operates without this antitrust exemption and seems to be doing fine, including, I would add, college athletics, which has been the subject of considerable recent antitrust litigation. So I think it's time to move on. I think this was never an antitrust exemption awarded by Congress. Congress has actually only operated in the other direction, reducing it, and may go even farther.
What about Julian's point about the cascade of litigation we're going to have if the exemption is done away with after 100 years? As
a litigator, particularly on the plaintiff side, I would press Julian, again, a good friend, for more specifics. I think antitrust scrutiny is warranted when it comes to some of the issues that we've been talking about today. And if those pro-competitive effects are actually borne out, right, by the factual record, then I suspect the types of conduct that Julian has been raising will endure, right? It will endure those antitrust tests.
I think another issue is that what does a repeal of federal baseball really accomplish in the face of subsequent congressional action, including the Kirk Flood Act? Again, the flood of litigation is going to be everything that was within the statute of limitations that hasn't expired, that people may have otherwise assumed was protected conduct. And again, I think it would be particularly conduct directed at the minor leagues. And I think it would have a destructive and corrosive impact. And you would see that investment in support of the minor leagues be reduced as a result of the increased cost of trying to defend it.
I think that sums it all up. There are good arguments on both sides, and it's a very knotty problem.
Thanks, Julian and Sathya, for a great conversation. And I do look forward to hearing more about this. Who knows what changes the future will bring. But before we let either of you go, we're going to ask you a question we ask all of our guests on our Curious Amalgam. And that is to tell us something interesting about yourselves, briefly, that we would not know if we only knew you professionally. Julian, you go first.
I suppose, apropos of the subject, it would probably be how bad at baseball I actually am, and what a traumatic experience it was being sent to summer camp for the first time, being given a glove and being sent out into the field, and never having been taught to catch. So as a 6-year-old, that's stayed with me, and I guess I really appreciate the experts who do it so well.
Oh, that's great. Sathya?
Gosh, I would say in my limited spare time, my ambition for 2023 is at least to begin constructing by hand a small cabin in the wilds of West Virginia.
Wow.
Yeah. What are you going to make it out of? Stone?
Wood.
Logs?
Wood. The cost of lumber is coming down again.
And then as the final end segment, we're going to ask the two of you to play a little game we call The Curious Hat.
And now it's time for The Curious Hat.
As part of this game, we will select a question drawn at random, one you have not heard before. So, Melissa, would you like to do the honors and read out the surprise question for Julian and Sathya?
Okay, gentlemen, given that we've been talking about what was America's favorite pastime, and I think many would agree that professional football has become, in the last century, America's favorite pastime, and given that the football playoffs are upon us, who's going to win the Super Bowl 2023?
Well, I have to go first and obviously plug for my Eagles, but
I'm with you there, brother.
I admittedly have a little bit of a bias there. But I would say this bias is maybe backed up by some evidence, so we'll see how it goes, but very optimistic this year.
In years past, as a New England native, I would champion the idea of the Patriots. This is not our year. I'm going to go with the Kansas City Chiefs.
We'll be back with an update.
That's right. Thank you both so much for being with us today. Thanks to everybody who's listening, and join us for another episode next week.
Thank you for listening to this week's episode of our Curious Amalgam. a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.